Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, I have.
And any additions or corrections or?
There's a lot of history, we understand, Your Honor, but discussed it with counsel also about restitution.
Speak up, I'm sorry.
I just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed, at least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation.
All right guys, buckle up because this courtroom hearing opens straight into a heavy reality check. The judge immediately lays out a prior guilty plea for theft, deferred probation, and thousands in restitution, setting a serious tone from the start. What makes it more intense is how quickly the defendant's criminal history starts piling up on the record, page after page being acknowledged in open court. You can feel the shift as the judge and attorneys begin questioning whether she fully understands the agreement she previously accepted. Restitution details start to blur, numbers are questioned, and accountability becomes the central focus. Before anything even progresses, the court is already signaling that this is far from a simple probation check-in and much deeper legal trouble is being unpacked in real time.
Right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I'm continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of criminal history?
Deferred, yes, ma'am. Either that haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
Another issue that I see on here also is the restitution, because it shows $9,400, but then that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, you know, I guess a bank fee.
Well, it says $500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was
$100 that sneaked in the bank.
Yeah. I wasn't aware of, Your Honor, when we did it and got when I got the PSIs, when I was notified, I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility joint and separately.
Now things start tightening up fast as the court digs deeper into the financial allegations and restitution breakdown. The judge is clearly not just skimming over the report, instead going line by line, questioning withdrawals, ATM transactions, and even cash app activity tied to the case. What stands out here is the attempt to separate responsibility, whether it was one person acting alone or a coordinated situation, but the court isn't buying confusion as an excuse. The defendant tries to explain parts of it, but the inconsistencies only raise more concern. At the same time, probation status from another county adds another layer of complexity, showing she is already under supervision elsewhere. The judge's tone shifts from procedural to skeptical, as the story being presented doesn't fully align with the paperwork in front of the court, building pressure with every clarification asked.
Right. It says, so
That's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the other status of another person. Your Honor. This is one that was charged. But not there's Cussing on there. But
okay.
she was wrong.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank. She was on the hospital. Not to my knowledge.
And hold on. So the probation's in Sutton County.
This is where the hearing turns more confrontational, as the court directly challenges the defendant's version of events against documented reports. The judge references detailed allegations involving bank withdrawals and coordinated actions, making it clear that liability doesn't disappear just because roles are disputed. Even when the defendant tries to distance herself from certain transactions, the court treats it as a shared responsibility situation. Then comes the turning point. The plea agreement itself is put under scrutiny, and the judge begins signaling hesitation about accepting it. The atmosphere shifts heavily when the judge openly questions whether there is enough clarity and accountability to proceed. You can sense the frustration building as the legal history, repeated offenses, and conflicting explanations all collide in one moment that starts pushing the case toward a reset rather than resolution.
Have they been transferred to Harris County? So you're going in person in Harris County? Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern. The state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
All right. So here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily to find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
Excuse me.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you
No,
do.
no, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings in back home.
Okay, you have lots of them that were at the same time for different offenses.
You know, we're going to be convicted.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still.
Now the situation escalates sharply as the judge begins reading out a long list of prior convictions, and this is where everything starts stacking against the defendant. We are talking multiple forgery cases, theft charges, drug-related offenses, and probation periods stretching across different states, all being laid out in open court. The judge is not just reviewing history, he is building a pattern of repeated behavior that directly impacts credibility and sentencing options. The defendant attempts to explain that some cases ran together, but the court firmly rejects that idea, making it clear each conviction stands on its own. As the list grows, the possibility of a lenient deal starts collapsing in real time. The judge ultimately rejects the plea agreement and resets the case, signaling that trust in compliance is too low at this stage to move forward under the original terms.
Different cases, November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases. That's not correct.
No.
So how many cases are you on probation for in Sutton County?
It all ran together. So
I understand it all.
one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It's not matter. My life's on.
Well, looks like you did that, not me. I'll see you in 3 weeks.
Bullshit.
Come on, hold on, get her. Don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
So my lawyer, he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either. You did.
He got me.
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your I
gotta go to work. So I'm gonna lose my dog and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
You want to push on me like that? You don't want to put this on Louis. Play me. I'm not going to do it like this. I'm not going to do it.
This final segment turns chaotic as emotions spill over after the judge raises the bond due to attitude and extensive criminal history. The defendant reacts in frustration, arguing, crying, and trying to justify herself, but the court is no longer receptive to explanations. The judge makes it clear that courtroom behavior matters just as much as the charges, and the outburst only makes things worse. Bond gets increased to $25,000, and that decision lands heavily in the room, effectively tightening control over her release conditions. What started as a procedural hearing ends with escalation, rejection of the deal, and a harsher legal position. And that's where we wrap today's breakdown. If you enjoyed this courtroom analysis, make sure to like the video, subscribe to the channel, and we'll see you in the next one.